A court just sent a message that could change the way permit delays are used against gun owners. And if your state or city plays games with renewals, this could hit a lot closer to home than you think. Pause. Quick question before we continue. Are you subscribed yet? If not, fix that right now, because these legal updates move fast, and missing one can put you in a very bad spot. Here's the truth behind the headline. This is not some magic one-line ruling that erased every permit rule in America overnight. That is not what happened. What did happen is still a big deal. A federal court in California already signaled that extreme concealed carry permit delays can cross the constitutional line. Then, the Department of Justice stepped in hard, first with an investigation and later with a lawsuit over permit processing delays. And now across several states, the bigger fight is becoming clear. Government cannot say you have a right, then bury that right under delay, silence, and paperwork until your permit dies on the vine. Here's what just happened. After the Supreme Court's Bruen decision, states were told they could still use shall-issue permit systems. In plain English, that means the government can require a permit, but it cannot give officials endless personal discretion to say yes to friends and no to everybody else. But Bruen also included a warning that a lot of people missed. The court said even a shall-issue system can be challenged if long wait times or huge fees end up denying ordinary people their right to carry. That warning matters more today than ever. Pause. Now, this is where it gets interesting. In Los Angeles County, gun rights groups challenged massive delays in concealed carry processing. We are not talking about a few extra days. We are talking about waits measured in many months. In that case, a federal judge found the challengers were likely to succeed on their Second Amendment claim against those 18-month delays. Later, a preliminary injunction order was entered that required specific steps and deadlines for one of the applicants. That is not a tiny procedural footnote. That is a court saying delay itself can be the constitutional problem. Let me break that down for you. Most people think the legal fight is only about whether the state can deny you. But the truth is uglier than that. The state does not always need to say no. Sometimes it can hurt you just by doing nothing. No denial letter, no approval, no clear answer. Just silence, month after month, while your application sits there. And if your current permit is about to expire, that silence can become the trap. Think about how crazy that is. You follow the rules, you apply on time, you pay the fees, you take the class, you do the fingerprints, you wait. And then, because the agency drags its feet, your permit expires before they finish the renewal. Suddenly, you are not a person waiting on government paperwork. You are a person carrying on an expired permit or a person forced to disarm while the same government that delayed you pats itself on the back for processing. That is the trap. And here's the part nobody's talking about enough. Lawyers challenging LAPD said they had members who filed renewal applications as early as LAPD allowed, which was 90 days before expiration, and still heard nothing when the expiration date was only days away. Their words were blunt. Those people would effectively lose the right to carry because of LAPD's delays. Read that again in your mind. Not because they were prohibited, not because they failed the background check, because the office did not move. If you're finding this helpful, imagine what you'll learn in my next video about the exact mistakes people make when they talk too much during a gun stop. Subscribe so you don't miss it. So what makes this story bigger than one city? First, the court already showed that delay games are not untouchable. Second, the Department of Justice has now made it clear that it is willing to treat some of these delays as civil rights problems, not just customer service problems. That is a major shift. In March 2025, DOJ announced a Second Amendment pattern or practice investigation into Los Angeles County over concealed carry permit delays. That alone was big news, but it did not stop there. Later, DOJ filed what it described as its first affirmative lawsuit in support of gun owners over those same kinds of delays. According to DOJ, after reviewing data covering more than 8,000 applications, the county had only 2 approvals, and some interviews were being scheduled as far as 2 years after a completed application. 2 years. For a right the government claims you still have. Pause. But wait, there's something even more important. This is not just about first-time applications. Renewal delays may actually be more dangerous for regular people because the clock is already ticking against you. If your first application is delayed, that is awful. If your renewal is delayed, you can fall off a cliff. Here's a hypothetical example to explain this. Imagine you are a small business owner. You close your shop late at night. You lawfully carry because you have cash deposits, rough neighborhoods, and a long walk to your truck. Your permit expires on June 1st. You filed your renewal on March 1st. The very first day your local agency allowed. You hear nothing. June 1st arrives. Your old permit expires. On June 5th, you are driving home, armed like you have been for years, thinking your renewal is still pending, so you should be fine. But your state may not recognize that as a grace period. If an officer stops you, that pending renewal may not save you. That is why this matters so much. A delay is not always just a delay. Sometimes it changes your legal status. Here's what most people get wrong. They assume that if they filed on time, the old permit stays valid automatically. In some places, that might be true if the law says so. In others, it may be false. And in some places, the answer is so muddy that you're gambling with your freedom if you guess wrong. Do not make this mistake. Never assume there's an automatic extension unless you have verified it. Under your state's law, or gotten clear written confirmation from the issuing agency or your lawyer. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Third thing you need to understand, courts do not usually love open-ended government excuses. We are short-staffed. We got a lot of applications. The system is old. Those explanations may describe a problem, but they do not erase a constitutional one. That was part of the point in the California litigation. The argument was simple. If government insists on a permit before you can exercise the right, then government cannot use its own slow process to destroy that right. And that logic makes sense, even if you are not a lawyer. Imagine the city told you that you have freedom of speech, but it takes 18 months to get a permit to hold a peaceful rally. You would know instantly something is wrong. Imagine the state told you that you can vote, but your voter registration would be processed sometime next year. You would not call that a delay. You would call that a denial in slow motion. The same idea is driving this gun case. Delay can become denial when it lasts too long. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who stay ahead of these legal changes instead of hearing about them after the damage is done. Click subscribe. Now let's zoom out, because this fight is spreading beyond one county and one renewal office. The bigger issue is whether states can use backdoor tricks after Bruen. Maybe it is a long wait. Maybe it is a social media demand. Maybe it is a private property rule so broad that your permit becomes useless the second you leave your driveway. Different method, same basic idea. The government says, sure, you can carry. Then it adds so many traps that normal people cannot safely use the right. New York is one example. After Bruen, New York passed a law that demanded concealed carry applicants provide a list of their current and former social media accounts from the past 3 years. That rule was challenged, and in 2026, New York agreed to stop enforcing that social media disclosure requirement against the plaintiffs in the Antoniuk case, and the state also agreed that the application form would not require that information. Why does that matter? Because it shows one more post-Bruen hurdle getting rolled back when it faced real legal pressure. Now, this is where the DOJ angle gets even more interesting. In the Supreme Court case Wolford v. Lopez, which challenges Hawaii's rule that licensed carry holders need express permission before carrying on private property open to the public, DOJ filed a brief supporting the challengers. DOJ argued that states cannot respond to Bruen by creating new restrictions that effectively negate the right to public carry. That phrase should jump off the screen at you. Effectively negate the right, because that is the exact fear with permit renewal traps too. On paper, the permit system exists. In real life, the right gets choked off. Why should you care about a Hawaii case if you live in Texas, Ohio, Florida, or Georgia? Because the legal principle travels. If the Supreme Court says states cannot nullify carry rights by using broad, indirect restrictions, that reasoning could influence future fights over delays, renewals, and copycat laws in other states. And if the court goes the other way, hostile jurisdictions may feel encouraged to get even more creative. Here's the part that shocked me. In the DOJ brief, the government argued that a state cannot evade Bruen by loosening one carry restriction and then replacing it with another that wipes out the practical value of the license. That is a huge point. Because a delayed renewal can do the same thing. The permit still exists in theory. But if the government can run out the clock whenever it wants, then your permit is only good when the agency feels like honoring it. So what should you do right now? First, know your renewal window, not what your buddy told you, not what a random forum post says. Know the actual window in your state or county. Second, renew early. If the law says 90 days, do not wait until day 60. If it says 120, do it as soon as the window opens. Third, keep records. Save your application receipt, save your payment proof, save every email. Screenshot the portal. If there's a delay fight later, your paper trail matters. Fourth, do not assume a pending renewal protects you. Verify that point, in writing if possible. Fifth, if the agency goes silent, politely push, ask for status updates, ask whether your current permit remains valid while renewal is pending. Ask what statute or policy controls that issue. Sixth, if the delay becomes extreme, talk to a qualified attorney. In your state, some of these cases are now showing that courts will listen when the facts are strong. And let me give you one warning. Do not turn this into false confidence. A good court decision in one case does not give you personal immunity. A DOJ lawsuit in California does not automatically fix your county in another state. A pending Supreme Court case in Hawaii does not change your carry status tomorrow morning. You still have to follow the law where you're standing today. Laws change fast, court rulings move fast, agency policies move fast. Subscribe now, because the next big carry decision could land soon, and I want you ready before your state starts updating the rules. Here's the bottom line. The biggest threat may not be the obvious ban. It may be the slow, quiet permit trap that turns a lawful carrier into a nervous guesser. A federal court has already signaled that extreme delays can violate the Constitution. DOJ has backed that fight with real action, and the broader legal war over post-Bruen workarounds is still building. Pause. So please, subscribe right now and stay with this channel. I spend the time digging through these cases so you do not get blindsided by them later. And one last simple disclaimer, this video is for education only. It is not legal advice, and gun laws can change by state, city, and even by the facts of your situation. Always check your local law and talk to a real attorney if your permit, renewal, or carry status is on the line.